the headlines are saying, which makes me angry, is, oh, Meghan Markle's, the USPTO, the U.S. Patent Trademark Organization, rejected Meghan Markle's trademark application for American Riviera Orchard. First of all, the USPTO has not rejected her application. All they've done is say, hey, we're not going to move forward with the attempted registration until you, or like her lawyers, make certain amendments with the attempted registration. When I tell you, the way that works, the way you file and the way that like the USPTO like responds is the most like generic sample document that is sent. Hello, this is the USPTO. There's an issue with your application. You need to, it's not like a literal, there's no judge's opinion in it, right? There's no like flair. There's no like commentary. It is literally the most automated ass service. None of the grounds cited in the USPTO's, it's called an office action. None of those grounds are fatal to her attempt to register the marks. And they can all be resolved fairly easily. They're not substantive, meaning like none of those issues require
it's not qualitative.
Yes, exactly. None of them require arguments in front of like a trademark examiner, for example. It's just helpful to understand that federal registration, trademark registration is accomplished by identifying the specific classes of goods or services for which your mark will be used. We call these international classes. If an applicant's trademark, so an applicant meaning Meghan Markle, her attorney, on behalf of her trademark, she's applying, saying, hey, I would like to register this trademark. If it's going to be used on, say, cars and dishwashers, they will want to identify at least 2 international classes on their application, class 12 vehicles and class 11 sanitary apparatuses. There are all of these different classes, a big bank, and you select which one does mine fall under. For instance, the examiner said that she needs to basically power up her identification of goods because some of the terms used are too broad and may involve goods that belong to multiple different international classes. The only substantive issue that may come into play is because basically she may want to argue partial refusal for being primarily geographically descriptive.
That's what I've heard.
Yes. The American Riviera Orchard brand is apparently going to offer a wide variety of goods and services, like 14 different international classes. And one of those is food items related to jam.
And that makes sense then, because Meghan said in her video, I didn't put these two together. She said it hemmed her in. They're saying the trademark could only be based on geographic location with the name ARO.
The reason why the examiner is going to say, hey, like this might be an issue is only if the examiner says, hey, like the American Riviera is actually a location.
A thing, right.
And so the word orchard is commonly understood to be a place where you might find dried fruit. So American Riviera Orchard isn't distinct to Markle's business. Any fruit peddler from Santa Barbara ought to be able to identify themselves as someone who's selling from American Riviera Orchard.
Makes so much sense.
Like, doesn't
it's
make
all
sense.
about jam.
It's not Markle related issues.